Good afternoon and welcome to the second episode of the Divorce Law Monitors webinar. We're glad you could join us today. We appreciate your time. My name is Robin Lynch Nardone and I'm joined by my partner Andrea Dunbar.
Good afternoon, everyone. Thank you so much for joining us today.
So today we're going to talk about the divorce process in Massachusetts and Rhode Island, how you go about initiating a divorce and what the steps look like. If you have any questions as we go along, feel free to put your questions in the question and answer box down at the bottom of the screen, and we will address those questions at the end of the webinar. I practice in Massachusetts while Andrea practices in both Rhode Island and Massachusetts. So for today, Andrea will focus her comments on Rhode Island law and I will focus on Massachusetts. Before we begin, we're just going to give a little bit of background about ourselves and our practices. So Andrea, why don't you start?
Thanks so much, Robin. As Robin said, I practice in Massachusetts and Rhode Island. I'm a partner in the private client group at Burns & Levinson. I have practiced for approximately 12 years. I focus my practice on all aspects of domestic relations in Mass and Rhode Island, including alimony, child support, custody, divorce, and I also do a fair amount of work with unmarried individuals who are touched by domestic relations issues. My practice also encompasses probate litigation and estate planning, so I'm very comfortable dealing with trusts and other complicated assets that may become an issue in divorce cases. I've been with Burns & Levinson for approximately 10 years now. I started my career as a law clerk with the Massachusetts Probate and Family Court, and I share this with people because part of my job as a law clerk with the Massachusetts Probate and Family Court was to help judges write decisions after trials. And oftentimes that was after divorce trials. And one of the things I learned is that if you can help it, you don't want the man or the woman in the black robe making decisions for your family. Robin?
Thanks, Andrea. So as I said, my name is Robin Lynch Nardone. I am the chair of the Divorce and Family Law Group here at Burns & Levinson. I have been at Burns & Levinson for over 20 years. I concentrate my practice on high net worth divorce, child custody disputes, marital planning in the form of prenuptial agreements, as well as postnuptial agreements. And as well, I practice in all aspects of modification, including alimony, child support, and custody modifications. I assist clients with obtaining orders for abuse prevention as well. I am a trained mediator, which allows me to act as a neutral to assist couples in amicably resolving their disputes. At Burns & Levinson, we have a robust probate and family law practice with 19 attorneys, several paralegals, and assistants who help clients through the divorce process. Our main offices are in Boston, but we have offices in Providence, Rhode Island, where Andrea is today, in Andover, Wellesley, and Hingham for the convenience of our clients who do not want to come into Boston. So in this second installment, we're going to talk about the divorce process, and Andrea first is going to lead us through the uncontested divorce process in Rhode Island.
Thanks, Robin. So there is actually no different process in Rhode Island, whether your case is contested or uncontested. You can file for divorce in Rhode Island when you actually have, whether you have or you do not have a signed agreement with your spouse. And that's different in Massachusetts. You have to have a signed agreement in order to file an uncontested divorce in Massachusetts. The contract that you sign in Rhode Island is known as a marital settlement agreement or a property settlement agreement. And oftentimes I hear, well, what should be included in such a document? And you want to address custody and parenting plan. In Rhode Island, you will often hear the terms custody and placement. Custody is generally decision-making, and placement is who the child resides with. Another thing you're going to want to address in your marital settlement agreement or property settlement agreement, that the terms are used interchangeably, is an asset division. So you're going to want to look at all of your assets and all of your spouse's assets and determine in that document how those assets will be divided between the two of you. Alimony will also be addressed in a marital settlement agreement or property settlement agreement. Alimony in Rhode Island has a higher standard than Massachusetts. Oftentimes you will see that it's waived. It's considered strictly rehabilitative, and lifestyle is not always necessarily a factor that factors into an alimony analysis in Rhode Island. Other issues you're going to want to address in your marital settlement agreement are child support, life insurance, health insurance, uninsured medical expenses, extracurricular expenses. And unlike Massachusetts, generally college is only addressed in a marital settlement agreement in Rhode Island where the parties agree, because the courts in Rhode Island do not have the authority to order one party or the other to contribute to the payment of college. Once whether your marital settlement agreement is finished and signed, or whether it's in the process of being finished and signed, once you file for divorce in Rhode Island, the court will issue what's called a summons. And that summons has to be served on the other party. And that summons, again, where it's amicable, we generally encourage that it be given to the other side and they can sign off on it without a constable or a sheriff appearing at their door. Other forms that you will need to file when you actually file for divorce in Rhode Island include a complaint for divorce. It includes a what's called a statement listing the children. The statement listing the children has to be filed in your divorce case, whether you have children or you do not have children. And if you do not have children, you would just write none on the form. Another form that has to be filed at the time of filing for divorce in Rhode Island is a financial statement. And it's referred to as the DR6, and that's the form number, but it's stuck as the shorthand name for the financial statement. On this form, you are going to have to list all of your income, assets, and liabilities. It's signed under the pains and penalties of perjury. It's an extremely important document in the case because the judge will review it as part of your divorce hearing. Additional forms that are going to need to be filed when you file for divorce in Rhode Island are it's a cover sheet, and it just has some general information on it. And you will also need to file a marriage certificate, and the marriage certificate must be from the city or town where you were married. They generally don't accept religious marriage certificates. And finally, you'll have to include in your filing a filing fee. Rhode Island is all electronic, so all of the filing will have to be done online. Once the filing is received, again, as I said, the court will issue a summons, and on the summons will be a nominal hearing date. A nominal hearing date is an uncontested divorce hearing, and it will be scheduled for approximately 60 days after the filing. If the court has the ability, oftentimes they will bump up that hearing if they are aware that there is a signed marital settlement agreement, meaning the parties have come to resolution on all issues. However, with the present state of the courts and COVID, it's unlikely to get earlier hearing dates. And in fact, in most instances, hearing dates are much further out than 60 days. Once the time passes and your nominal hearing date comes up, pre-COVID, what would happen is you would appear in court with your spouse. The agreement would be presented to the court for approval. The parties will swear under oath, and both parties will be required to take the witness stand. To do this, they will swear under oath that the agreement is fair and equitable under the circumstances and that it was entered into freely and voluntarily. As I said, during these hearings, testimony is taken. So both parties take the witness stand and both parties are asked questions by their attorneys. And if they are unrepresented, then the judge typically leads the parties through the hearing. Rhode Island, unlike Massachusetts, does not have a requirement to take a parenting class if there's children involved. And oftentimes, marital settlement agreements, property settlement agreements are reached via mediation or negotiation amongst lawyers. Rhode Island actually has a mediation program available to litigants, but there must be a case pending in the court in order for the parties to avail themselves of mediation through the court. Once the nominal hearing is completed, the judge will issue a decision from the bench. When that decision is being read, the court officer stands by the doors to the courthouse, and no one can go in or out the courtroom, not the courthouse. No one can go in and out while the judge is giving his or her decision from the bench. And I tell people this because when I was a new lawyer and I didn't realize that this is what happens, I came to a courtroom while a judge was giving a decision and was like fighting with the court officer to get into the courtroom, not realizing that this is common practice. So if you're getting divorced and you can't get into the courtroom, there is a reason why. Once the judge gives the decision, it's up to the lawyers or the parties to reduce that decision to what is called a decision pending entry of final judgment. And this decision is what is on file with the court until such time as the final judgment can be entered 90 days after the nominal hearing date. The final judgment, once 90 days has passed, can be entered. That final judgment would be prepared by the lawyers or by the parties if they're unrepresented. And you have up to 180 days after the nominal hearing date to enter the final judgment. And after the final judgment enters, there may be some post-divorce issues such as quadros and dividing assets that you will want to either work with your attorneys or work with your spouse to resolve. Robin?
Okay, so I'm going to give some information on the uncontested divorce process in Massachusetts. This is known as a joint petition for divorce or a 1A divorce. It requires the parties to resolve all of their issues before anything is filed with the court. If there are children under the age of 18, both parties must attend a parenting course sanctioned by the court. They have a list of courses that you can choose from to attend and obtain a certificate from that program. You need to do that prior to filing the 1A joint petition for divorce. All of the same issues that Andrea described as needing to be contained in the agreement in Rhode Island also need to be contained in a separation agreement in Massachusetts. Additionally, because Massachusetts courts can order parties to pay the college costs of their children up to age 23, in Massachusetts, you would include provisions relating to how any college costs for children will be paid in your case. The separation agreement is the document that it's called the separation agreement, but it is the divorce agreement. That's just the name used in Massachusetts. That agreement can be reached through mediation, through conciliation, or any other type of dispute resolution, or simply through the assistance of counsel. Given that the separation agreement contains important rights and obligations, we do not advise that people try to write this document on their own. It's important that you have counsel looking at this on your behalf. Burns and Levinson does offer mediation in Massachusetts, and we also advise clients who have gone through mediation with another mediator. It is important to have an attorney on your side look at that separation agreement and advise you as to your rights and obligations before you sign off, even if you've reached that agreement in mediation. The mediator is working for both parties and is a neutral. They're not looking out for the interests of either party. So if you go to mediation, remember it's important to hire a lawyer just to look over the agreement that you came to. So once you've done that, there's a filing packet that needs to be filed with the court. It contains that joint petition for divorce, which essentially sets forth your names, addresses, your marriage information, and information about your children. An original of the marriage license, as Andrea said for Rhode Island, the same for Massachusetts. You need the Marriage license from the city or town in which you filed your intention to marry, not something from your church or synagogue or other religious certificate. You need an affidavit of irretrievable breakdown, which is an affidavit from both parties essentially saying there's no hope of reconciliation. If there are children, you need that parenting certificate, as well as an affidavit disclosing care and custody, which is a court form to indicate that your children have or have not been involved in any other court proceedings relating to their custody in the past. You need that separation agreement, and you also need a financial statement. In Massachusetts, the financial statement is known as a Rule 401 financial statement, where you list all of your income, assets, and liabilities, similar to what Andrea described in Rhode Island. This is signed under the penalties of perjury, and it is an important document in your case, so it is important to take time to fill it out properly. You need to consult your tax returns, your bank records, your pay stub to get correct information to put on that form. It is often necessary as well to speak with your bookkeeper, your accountant, or your financial advisor relative to information with which you may not be intimately familiar with, which they are, that can help you fill out this form. The judge will review your financial statement, separation agreement, and other documents as part of your case. Therefore, it is important that your financial statement be accurate, and you should have an attorney work with you to fill out that form. There is also a filing fee in Massachusetts when filing an uncontested divorce. After all that paperwork is filed, the court will then schedule a hearing to present the agreement to the judge. The judge will review the agreement and your financial statement to determine whether the agreement you have reached is fair and reasonable. Both parties must also testify to the court that they have read this agreement, they have signed it freely and voluntarily, that there was no coercion, and that they believe it to be fair and reasonable. Under COVID, many of these hearings have been happening by either telephone or by Zoom instead of in person. The courts are just opening up this week, so the practice may be going back to going into the courthouse to present the agreement, but know that sometimes it's happening by telephone or by Zoom. Under a 1A divorce, the joint petition, your divorce is final 120 days after the agreement is approved by the court, which means you remain married for 120 days for tax purposes, and you also cannot get remarried during that 120-day period. So this is the hearing in the courthouse is kind of a short 10 or 15 minute where the judge asks you if you've read it, the agreement, you understand it, and oftentimes I hear people say, that's it. It's a 25-year marriage, and in 10 minutes it's over. It is a short hearing. When everything's been resolved, there's no need to belabor it, so it's a quick hearing. So that's it for the uncontested divorce in Massachusetts. So Andrea is now going to give us the lowdown on what happens with a contested divorce in Rhode Island.
Thank you, Robin. So just to piggyback off of what Robin was saying about the courts in Massachusetts using telephone or Zoom, in Rhode Island, the courts are using WebEx, which is a platform similar to Zoom. And so if you have a hearing in Rhode Island, that hearing will most likely be via WebEx during the pandemic. And the courts in Rhode Island, for most purposes, are not currently open. As I said about uncontested divorces in Rhode Island, the filing process is the same for a contested divorce in Rhode Island. You will still receive a summons, and ever optimistic, the summons will still include a nominal hearing or uncontested hearing date. The hope is that the case, even if contested, with the 60-day waiting period, possibly longer now because of COVID, that the case could still be resolved by that date. At the time of the filing of a contested divorce, as well as an uncontested divorce in Rhode Island, the court also issues what are called automatic orders. And these automatic orders are in place to protect assets and your children, and just to make sure that neither party attempts to obtain an upper hand by doing something underhanded with the children or with assets. If the case remains contested by the time of the scheduled uncontested hearing, the court will put the case on what's called the contested track. And this allows for the scheduling of status conference dates, pretrial conference dates, and these are all interim hearings with the court in the hopes of resolving the case ultimately. The courts in Rhode Island tend to allow attorneys a lot of leeway in terms of settling the case, and oftentimes they are very liberal with continuances of status conference and pretrial conference dates, with the understanding and hope that the attorneys involved in the case are doing everything they can to move the case along. If the case has been pending for more than a year, that is when the judge is going to become a little bit more hard about either getting the case to a final settlement or getting the case to trial. One of the things that you will often see in a contested divorce case is the filing of motions. And this you will see in Mass and Rhode Island. And a motion is just a formal request to the court that they do something. And I will refer you to my recent blog post on the Divorce Law Monitor that talks about motions for temporary orders in Massachusetts, or motion for temporary allowances, as they are called in Rhode Island. And this is generally an ask for interim orders that need to be in place while the divorce is pending. For instance, issues relating to the children, issues relating to support, issues relating to sometimes finances. Once a contested divorce is filed, the parties will engage in a process known as discovery. And in its simplest form, discovery is an exchange of documents, an exchange of information. So I often get the question, well, what are the most important documents for me to collect at the outset of my divorce? And I tell people that, if you are not the spouse that has managed the finances, and there is going to be a bit of a learning curve for you, then I suggest that you find every document you can find with a number on it and give it to your lawyer or your financial advisor to help you navigate the process. And so some of the most important documents that we see in divorces are tax returns, bank statements, credit card statements, investment account statements, deeds, mortgage statements. So all of these things are important for your attorney to have, and more than likely are going to be requested by your spouse and your spouse's attorney during a contested divorce process. Other discovery tools that we have in our toolbox are subpoenas. And a subpoena is just a formal request for documents from a third party. They're generally used if one party or the other doesn't have access to the documents, or if one party is not being cooperative and not turning things over. Also, we tend to use subpoenas sometimes because it's just generally a faster process. I can get documents much more quickly from Fidelity than I can necessarily get from the other party. So oftentimes clients will be a bit unnerved by a subpoena, but I tell them that a subpoena is a document that is actually very helpful, and it moves things along. And frankly, it takes a lot of the pressure off of the parties themselves. Other discovery tools are depositions, which is a process by which either one of the parties or a third party gives testimony under oath, and that testimony is then used in the divorce process. We also use what are called interrogatories, which are written questions that are answered under oath. And sometimes we use what are called admissions, which are short statements that a party is either asked to admit or deny. As I said, the courts in Rhode Island generally want divorce cases disposed of within a year. And again, This has definitely been impacted by COVID, and some judges tend to be a little bit more lenient on this requirement. Ultimately, if you and your spouse cannot come to an agreement, then your case is going to have to go to trial. And trial is always a last resort. Robin and I tend to settle probably about 95% of our cases. But if a case has to be tried, we are fully prepared to try that case. Trial involves testimony taken in court in front of the judge. In family court in Rhode Island, generally there's no jury for a divorce case. I say generally because it's not every case in family court in Rhode Island has no jury, but a divorce case does not have a jury. And during a trial, you would enter exhibits, which are documents that are entered for the court's consideration. And then after trial, the judge will issue a ruling. And again, this oftentimes is a verbal ruling that will then be reduced to writing by the attorneys. So now I'm going to turn it back to Robin to talk about the contested divorce process in Massachusetts.
Okay, thank you, Andrea. So the contested divorce in Massachusetts is known as a 1B, excuse me, and it begins with one party filing a complaint for divorce, where that party becomes the plaintiff in a lawsuit and the other spouse is the defendant. The complaint gives notice of the divorce action and the grounds for filing. In Massachusetts, we still maintain fault grounds for divorce, as well as the no fault ground, which is irretrievable breakdown, which essentially means a party needs to say, I no longer want to be in this marriage. After the filing of the complaint, the court issues a summons. Summons is the notice to the defendant that an action has been filed. It has to be served on the defendant in hand, meaning the constable brings it to the person and has to place it in their hand along with a copy of the complaint for divorce and the other documents that are filed with it. Another option is that the defendant can accept service by signing the summons, which essentially just means I've received this, I'm aware of this action. It doesn't mean you're consenting to the divorce or any of the requests made by the plaintiff in their filing. There is an automatic restraining order on assets in Massachusetts, which applies to the plaintiff upon the filing of the complaint, and it applies to the defendant upon the service of the summons. It prohibits the disposal of assets. It also prohibits either party from taking on any debts which would encumber the credit of the other party. It also requires that certain insurances remain in place and that no changes be made to beneficiary designations. After the service of that summons, certain timelines begin to run for your action to move forward in court. You have 30 days after service of the summons to register to take that parenting course that I talked about previously. The course is now offered online as a result of COVID, so there are ways to participate in that course via Zoom. You cannot take the parenting course at the same time as your spouse is taking the course. You just need to elect different courses at different times. 45 days after the service of the summons is there a requirement to exchange financial statements. Oftentimes, if there's a motion, which Andrea described in Rhode Island as a request before the court, you would need to fill out that financial statement to bring it to court for that motion, which may be prior to 45 days. And you will fill out a new financial statement multiple times in a contested divorce because you will need a new one every time you appear before the court when there's any issue financially related for the court to resolve. Then you have 45 days after service of the summons to exchange Rule 410 documents. Rule 410 requires that the parties each provide to the other their 4 most recent pay stubs, 3 years worth of tax returns, bank statements, investment account statements, and retirement account statements, any loan applications, as well as documentation on the health insurance that is available to either party. Those are called mandatory discovery exchanges. In a contested divorce, there can be additional discovery beyond Rule 410, and those are the same things that Andrea described in Rhode Island: depositions, subpoenas, document requests, interrogatories. Again, the important documents for you to have in Massachusetts would be similar to what Andrea described in Rhode Island. All of those documents under Rule 410, as well as anything else financially related that would relate to an asset that needs to be divided, expenses for your children, or as Andrea said, anything with a number on it that would be helpful to your counsel. Once you've gone through those sort of mandatory steps, the court may or may not issue temporary orders if a party brings a motion before the court asking for orders on such things as support, custody, or other issues that need to be resolved immediately and cannot wait until your case gets to the trial stage. There may be a guardian ad litem investigation in your case. This is if there's contested custody issues that are large enough that the court wants to have an outside person look into it, they appoint a guardian ad litem. Typically, it is an attorney or a psychologist or a psychotherapist or a social worker who will speak to the parties, the children, and any collateral witnesses to help the court by gathering information about what is in the best interest of the children. The next step would be a pretrial conference, which is a hearing before the court to let the court know what are the issues in this case that are preventing resolution of the case. The court will provide feedback, and sometimes cases actually settle at the pretrial conference after receiving that feedback from the judge. If your case does not settle at the pretrial conference, the court will schedule trial dates and sometimes status conference before the trial to again see if they can move things forward and get to a resolution short of having a trial. As Andrea said, the vast majority of our cases settle. It is our goal to help parties settle their cases rather than letting the judge decide issues in their case. But if the case cannot be resolved, we are prepared to take a case to trial. If the case goes to trial, there are no jury trials in Massachusetts on divorce matters, but it is a hearing in the courtroom where testimony is taken, similar to what you see on television where parties sit on the witness stand, witnesses come in and sit on the witness stand. Sometimes there's experts to provide information relative to values of the party's assets. And then after the trial, the judge issues a judgment. The timeline for the judge to issue the judgment can vary widely depending on what the judge has on his or her plate in terms of how long it will take them to write that judgment. Once the judgment issues, it does not become final for 90 days after the judgment, which means you remain married for 90 days after your judgment of divorce issues. Again, you're married for tax purposes and you cannot remarry during that 90-day period. We're nearing the end here. We want to be mindful of people's time. If anyone has any questions, I don't see any now, but feel free to put them in the box. Otherwise, we will wrap up. We hope we've provided some helpful information for you. Andrea, do you have any last words you want to share before we wrap up this webinar?
Sure, thanks, Robin. So I know this was really truncated and we kind of threw a lot of information at you all at once. So if you have any specific questions that you don't feel comfortable dropping in the chat, please feel free to reach out to myself or Robin, and we're happy to answer any questions that you have. I think that just some final thoughts I wanted to leave with are that the divorce process, whether contested or uncontested in Massachusetts or Rhode Island, can be extremely nuanced. And especially when you're dealing with high net worth individuals. Going it alone without representation can be a recipe for disaster, especially because property divisions, both in Mass and Rhode Island, once entered, unless there are very finite circumstances, cannot be changed. So representation by a good attorney, a good experienced attorney is really key. And I'll leave you with, you know what they say, a person who represents himself has a fool for a client. So thank you very much for joining us today, and I really appreciate your time.
Thanks, everyone.
Thank you.